Hi again, and today we're speaking to Felicity and guest, and we'll be discussing a quite recent case in terms whereof a husband who offered 2,000 Rand was hit with a 70,000 Rand monthly maintenance bill. So he had to pay 70,000 Rand. And that was a High Court decision that was handed down quite recently in the cases of B versus B. Felicity, you've been following this case and you've been reading up on it. Just give us some information and some background information regarding this case.
It is quite a recent application. It was the first application went in December last year. But what I'm interested in is the similarities, or that it can possibly go the same way as the Potgieter case went, and we saw that timeline of years. Because in this particular case,
just stop there. Many people won't know, listening to this, won't know about the Potgieter versus Potgieter case. Can you just give us some background information on the Potgieter case and how you're going to tie it in with this case?
Sure. So there was a Rule 43 application made by Louise Nell, and he did not adhere to the Rule 43. And then eventually the divorce was granted, and he complied for 3 months on her maintenance and a year with the children's maintenance, and then he stopped complying. And that application, they got divorced in 2012. The Rule 43 application was made in 2010, and the ruling was made in 2018. So we're looking at like 8 years for a ruling to be made, for him to be found guilty, but that was a criminal process. But what we learned from that particular case is it took 8 years. There was a Rule 43. She was confident that she would get some financial support for herself and her children, and he did not comply, and she still has not got that money. So that's where, for me, I will watch this case with interest, because it's a recent ruling. It was made earlier this year, beginning of this month. And I hope that we don't see a replica of the Potgieter case.
Because what happened in the Potgieter case, he's still incarcerated, and she's still left without any money for maintenance.
Correct. So if the Rule 43 has granted her nearly 70,000 Rand a month maintenance, that's fantastic on paper. But we've seen in the Potgieter case that it does not translate to compliance and with money in the bank. So in this particular case, he was paying her 2,000 Rand. And the court, assessed his financial means in this Rule 43 application and granted her nearly 70,000 Rand a month. So wonderful on paper. But these are the aspects that I really want to also make highlight of, is that money is used as a means to punish. And if we look at in the context of gender-based violence, and why I advocate under gender-based violence, is because of the inherent economic privilege of men and the imbalance of power in relationships. And in this particular case, and it states in the judgment that further evidence is that she suffered a long history of abuse, intimidation and violence at the hands of the respondent, who has a controlling personality. And this is the important aspect, because this controlling personality, as we have seen in the Potgieter case, is that this is not going to stop. The controlling behavior is going to continue, and unfortunately, the law is used because if he doesn't comply, what is going to be her recourse? Is she going to go back is she going to go to maintenance court? Is she going to make another high court application? And is it going to become, is he a vexatious litigator? It's not that he doesn't have the means. That's been established, he has the means, but he's not going to pay the money. And I can almost bet my last dollar on this, is that this money is not going to be paid to her, because it speaks to the behavior. And that's the aspects that is not always taken into account, like after these rulings are made, is recognizing the pre-existing behavior. And that's where my research and where my interest has been. So does this behavior stop? No, it doesn't stop. It changes shape and form. because it's all about controlling. And post-relationship, money is the most powerful tool to continue, because he is in control of he's in control of the money. So he can continue controlling by means of frustrating her financially and her children.
And that also came out in the court judgment. I mean, he went there and he offered 2,000 rand. And once the court did the investigation and they scrutinized his financial situation, the court awarded 70,000 rand at the end of the day.
Absolutely.
So he actually tried to manipulate the court in making them believe that he could only afford 2,000 rand as opposed to 70,000 rand, which was well within his means.
Sure. So one can see exactly what his intentions are. I mean, it's obvious, but you know, there's not enough research in this aspect of these cases, and why it's so important that the abuse aspect and understanding how money is used to abuse and control. Then, and we need to establish case law on this, so that, you know, going forward, that this is minimized, because this is constructive financial abuse. This is absolute, and you're going to see this playing out.
Well, looking at the order that the judge made, the order did not say it's a point blank amount of 70,000 rand. They actually, the judge went and they split it up, and they said, you know what, maintenance, spousal maintenance for herself in the amount of 20,000 rand, maintenance for the minor child 15,000 rand, amount of 9,600 rand for medical aid. There was 7,400 for specific for household goods. There was for accommodation 15,000 rand. So it was quite specific. So the judge actually applied his mind and say, but you know what, they probably recognized that there was some form of financial abuse, not only towards the children and towards her, but also towards, you know what, withholding funds for accommodation, for medical, for household goods. So sure. would you say that the judge was cognizant about, you know what, the financial abuse which occurred and formulated his judgment accordingly?
I think that there was some cognizance of that, but again, I'm going to reference the Potgieter case. He paid spousal maintenance, which was also separate, for 3 months, and then he stopped paying her, but he continued paying for the children. Okay, so you can see where the abuse was directed at initially. It was directed at her.
Fully understood.
So again, you know, it's the same. I mean, he can decide, oh, I'm only paying, he'll pay the children's portion for a period of time. And if he finds that that is not having the desired impact on the real victim, which is his ex-spouse, then he will change tactics again. But it will always be about the money. And that's what we need, you know, that's what our courts and our judges need to be aware of, is how they manipulate it because of the long process, unless these are urgent applications. So if he doesn't pay spousal maintenance, but pays the children's maintenance and medical aid, for example, how long is it going to take her to get this enforced?
Yeah.
How long is it going to take her to get attachment? So again, you know, it's the systemic and the structure that facilitates the extension or the continuation of this abuse. And then that's where we start seeing vexatious litigation.
Mm-hmm. I also saw on some of the other groups mentioning and referring to this case specifically, which is quite a recent case, that some of the people in the legal fraternity actually wanted the judge to include a penalty clause to say, but you know what, if you default on this, like a suspended sentence, then that would be the recourse. You know what, you have to comply with this, otherwise you will be jailed for a certain period of time. What's your personal feeling regarding that? The criminal sanction of not compliance with a court order.
Okay, where I would have liked to have seen that inclusion in this particular case is under the Domestic Violence Act protection, because that is immediate arrest. If you don't comply, or you violate the protection order, then you can be arrested immediately. So, again, this is us and family law operating in silos. And if that judge was he mentioned the abuse. So and the attorney, for that matter, her legal counsel, should have brought in the provisions of the Domestic Violence Act. And that's where
but one should also
Correct.
remember that this was a Section 43. That was just an interim order pending finalization of a divorce order for her to get emergency monetary relief. Surely then the domestic violence courts could also be brought on board if there was financial abuse, that the applicant could go to the domestic violence court to obtain a separate protection order for economic abuse.
Okay, I disagree, because all of these fall under family law and under the family courts. Okay, although this is a high court application, again, the onus now is on the victim. It's shifted, the responsibility is shifted to the victim when it's known, it's noted in this particular case, but the responsibility shifts back to the victim to go. And we know that trying to get a protection order for economic abuse in the domestic violence courts is almost impossible, because they don't understand it. They will be referred back to the maintenance court. This is the pattern, and this is the problem, and this is why it's so difficult to enforce these things. I think we need to start changing our perspective and go, this Rule 43 has been granted for protection. It's been granted. And what is protection? Protection is protection to shelter, protection to food, protection for healthcare. That's what it's based. That's what this ruling is. So, that protection, she shouldn't have to go to the domestic violence court. There should have been a provision in here. This High Court should have included a provision taking into account the Domestic Violence Act, or finding some previous citation of it to be able to put in some kind of immediate recourse. Because if you're going to leave it up to the judiciary, we're going to see another 10 years, just like the Potgieter case.
We'll definitely be keeping our eye on this case, and we'll be following that. Thank you, guys. This was Felicity and Guest talking about the B versus B case that was quite recently handed down in terms whereof a husband who only offered 2,000 Rand was hit with a 70,000 Rand maintenance bill to be paid monthly. Felicity, thank you so much for your time.
Thank you, Eugene.